Good morning, Ms. Manlin. Mr. Hillman, good morning.
Good morning, Your Honor. Good morning, Your Honors, and may it please the Court. My name is Robert Hillman. I represent the town of Nantucket, in this case acting by and through the Nantucket Memorial Airport, which I'll refer to as the airport. The airport seeks an order reversing a judgment of the Nantucket Superior Court, which set aside the airport's title in certain land under a 1968 taking order in favor of a 1988 deed acquired by the appellee, William Devine, trustee of the Realty Trust, which I'll refer to and is referred to in the briefs as the trust. The trial court erred as a matter of statutory interpretation in this case by writing a requirement from Chapter 79, Section 7D, which refers to a reasonable investigation of the identity of the holders of interests in land into as a condition precedent to an effective taking under Section 3 of Chapter 79, which is
well, surely some notice has to be given to the owner of the property that you're about to take from him or her.
Your Honor, I believe that under Massachusetts law and under the law of other jurisdictions that have functionally identical taking statutes, that is not the case.
No notice is required for the government to come in and take my home? No notice to me?
There is, under Massachusetts case law, the notice is the due process requirement is that you have a constitutionally protected right to damages for a taking.
Oh, no. Is that true? You mean I have no opportunity even to object after the fact that you've taken that land for not a public purpose?
Oh, after the fact, Your Honor, absolutely. The question here is, and that's where Section 7D is effective. 7D is a tolling statute which permits the owner of land to...
So you've got to give me notice before your taking is effective in any kind of sense?
No. I submit that under Massachusetts law, case law, that's not the case.
Well, that can't possibly be so. It may be that you may have title for a moment, but once I get notice, I have an opportunity to contest that taking, do I not?
Yes, you do.
So how did you give the notice to the owner here?
In this case, we did not give, under the trial court's finding, there was no direct notice given. Under Massachusetts case law, there was constructive notice given.
In what sense?
By the filing of, by the adoption by a public body of a taking order under Section 3, and under Section 3, the recording of that taking order in the Nantucket Registry of Deeds.
How is anyone, anywhere, any place, going to find that?
It would be, first, I'd submit that under the case law that, and well, that's set forth in the brief, is that the requirements of indexing that I think are the crux of this case are not prerequisite to the effectiveness of the taking. Under Massachusetts case law, in repeated cases, it is if it's in the Registry of Deeds, which it is. It's the taking order is there. It has a book and page number.
What is it? So the taking order is there.
The taking order was.
It's in the building.
It's in the building. It's in the books. It has a book number. It has a page number.
It doesn't have my name on it. I'm the owner. It doesn't have my name on it.
You are the owner. And in fact, but Chapter 79, multiple sections of Chapter 79 permit taking authorities to take property from owners unknown. It's expressly authorized in this.
Owners unknown, but I'm known. The judge, in essence, found that this owner was known, not an unknown owner, because you made no effort, not you personally, the town made no effort to find out who the owner was. So I think we have to conclude from the judge's finding that the owner was indeed known.
Well, I think susceptible to being known, and that's what Section 7D protected Mr. Carmer against. Section 7D said that the town, the airport, could not cut off Mr. Carmer's rights to collect constitutionally mandated compensation for the taking, and without a reasonable investigation under 7D into his identity. The penalty for the failure of undertaking an investigation to find Mr. Carmer is that the town can't cut off Mr. Carmer's right to be compensated.
Well, could he cut off his right to contest? I mean, you can only take for public purpose, and here this land is set idle for no purpose for 30 years, 40 years.
three responses, I think. The first response is that well, taking your points, is that I'll try and take them backwards.
So I got no notice. You've taken my home. I'm still paying taxes.
Well,
you've taken my home. I have no notice. You're not using my home.
In this case, he wasn't paying taxes. It had fallen off the tax rolls, and there was a 30-year gap.
But whose fault was it that it fell off the tax rolls?
That's not clear. There's no,
Okay.
and that's, I don't want to get ahead of myself. There's another argument for preserving these kinds of takings, which are authorized by the legislature, because this is a problem that's inherent in the rule suggested by the trial court, the rule urged by the trustee.
But he was paying taxes from 1988 to 2001 or 2000, $46,000 in taxes.
The two owners down from Mr. Karmer went back in and redeemed the back taxes on the property to avoid, and the record indicates there was a tax.
And the town took the money.
Undertook a tax taking of this property, even though it turned out that it was subject to a taking of the airport. To preserve him from losing the title to the land on the tax taking, Mr. Devine, the trustee, redeemed the title on the tax side. But the manner in which the statute is effective is, and the cases from this court indicate that once a Section 3 order is duly adopted, and there's no question in this case that this order was duly adopted. Justice Cordy addressed the issue of was this taken for a public purpose, because, as you correctly point out, it was open land and remained open land. But the airport put evidence in the record, and I believe the trial judge accepted in his findings that an airport uses open land. If you look at the taking orders in this case, they took multiple parcels, and they actually took different interests in the different parcels, including things called navigation easements. They're located near the end of a runway, and as the airport.
This isn't one of those.
It is not. It's next to one.
What I don't understand, though, is if somebody were to trace the grantor-grantee index, they would not find this taking. Is that right?
They would not if they went back from Karmer. They would not have found this taking because there's no grantee into grantor Karmer
To Loomis. From Loomis to
Loomis
to Karmer.
Well, no, there's no grant.
From Loomis to Loomis.
Well, I think the crucial one is there are two crucial points in the title history. You're right. The town is not indexed, or Karmer is not indexed as a grantor to the town. In other words, the taking order took the property for the town, and if you look for that, you only find the town as grantee. Why? Because it's an owner. It was taken as an owner's unknown taking. It would have been indexed. The grantor would have been unknown owners, which is expressly authorized by multiple sections of the statute. And under the theory advanced in this case, the construction of the statute, if you accept the theory that the indefinite reference statute, Chapter 184, Section 25, absolutely requires Karmer's name to appear in the grant or index to the town for this to be valid, then you have to read out multiple sections of Chapter 79 which expressly authorize owner's unknown takings. So
Mr. Hillman, may I ask this question? Of course, there are certain circumstances in which owners are unknown, and the legislature has provided. That seems rather to beg the question, because owners unknown obviously should be a position of last resort, because it interferes with the grant or grantee, and for better or for worse, that's how most people do title searches. I know the brief from the Real Estate Bar Association, the Abstract Club, was filed late, and so it was after you had filed your brief. But have you had an opportunity to take a look at their brief?
Yes, I have.
And their position is that requiring the town to have done some further investigation is not inconsistent with existing Massachusetts precedent. Your argument here is that the Massachusetts law is clearly on your side, correct?
I am.
they take a different position. Do you want to respond to their?
Yes, I do, and I'd like to respond by identifying a case, two cases from the First Circuit that the Real Estate Bar Association and the trustee ignores, and it ignores because it is uncomfortably close to the facts and circumstances of the factual and legal issues in this case. The trustee points out in its brief that this is a case of first impression in the Commonwealth, and they're right, but it's not a case of first impression at the Nantucket Airport. There are two cases cited in our brief, United States versus 125.2 acres of land and United States versus Haddon. Both of those cases arise out of takings of land at the Nantucket Airport by the Civil Aeronautics Board under a federal statute which is, in terms of its requirements for notice, functionally identical, or at least very, very similar in material respects to Chapter 79 in terms of the requirements for taking and notice and filing. In those cases, the conduct of the taking authority was substantially worse than the findings of the trial court in this case. Indeed, instead of being, and one of the points I forgot to make with you, Justice Cordy, was that there is a subsidiary point in this case concerning whether or not the airport does not accept and challenges the legal standard for whether or not this was found to be an inadequate search. The case law indicates that there are standards for a reasonable search, and while the judge applied them in this case, he went beyond the cases. I refer specifically to Hardy versus Jekyll, because this, on the record in this case, required a trip to New Jersey, which is outside any reasonable search ever imposed by a Massachusetts court. Now, back to the federal cases, and in fact it's a companion case to Hardy versus Jekyll. The Civil Aeronautics Board took land at the Nantucket Airport. Not only did they fail to give notice to known owners on the island, some of whom were actually the spouses of public officials, but the court found that the conduct and failure to give notice was particularly egregious. In fact, the notice under the federal statute wasn't even to be found in the Nantucket Registry of Deeds. Under the federal statute, it got filed in the U.S. District Courthouse in Boston. And the court asked the question, the exact question the real estate bar asked, do the concerns of the statute and do the concerns of due process under the cases relied on by the Real Estate Bar Association mandate removing title from the United States and delivering it, in one case, 125 acres, back to the owner from whom it was taken. In the other case, Haddon, back to somebody in the trust position, a bona fide purchaser. In that case, someone who was a successor to a tax taking of the same land by the town. And in both cases, they found that the concerns of due process and statutory interpretation required that the owner who was deprived of the land and not given adequate notice had to be paid, and that no defenses of statute of limitations as to the right to payment for what was taken away from the owner attached, and the taking authority, in that case the United States, and in this case the town, is still responsible to Mr. Carmer.
So your bottom line position basically is that all the town is obligated to do right now is pay Mr. Devine a sum of money with interest.
Indirectly, yes. The argument, I think the logical requirements of the statute and the case law is that the town is still responsible to pay the estate of Carmer a certain amount of money. I would say under other cases, including 125 acres, that the trust would likely have an equitable lien over that payment. So we are constitutionally responsible to pay Carmer the fair value of the property in 1968 plus interest.
Plus the taxes back, of course.
The taxes, that's, of course. I mean, we collected taxes on land that we owned, and there's no question about that. The trust bought this land through a straw in 1985 for $7,500 and is actually asking this court to award more relief than Mr. Carmer could get if he were standing before you.
That's beside the point. In other words, the fact that he is successor to Mr. Karma doesn't mean to say that the relief is necessarily identical. All kinds of things change. I mean, it's possible that he could get different relief.
Why couldn't Mr. Karma get his title back?
Because there's no formal defect in the taking, and under the construction.
Well, if we suggest that he should have had notice and didn't get notice, so he was in no position to contest, and you didn't pay, by the way, under the statute either, as you're supposed to do. So the town didn't give anybody notice and didn't pay, the record owner notice and didn't pay anybody. So how do you get title? I mean, just as an equitable matter, how do you get title if you take something from someone without giving them notice and don't pay them?
I'm out of time, but with your permission, I'll answer your question. The town gets title because of the manner in which the legislature set up Chapter 79 and the manner in which the courts have determined how rights are apportioned if there is a failure to give notice. And the cases, again, they're cited in both briefs. That the giving of notice is not a prerequisite to the effectiveness of the taking, but that we have to pay Mr. Karmer his constitutionally protected interest in just compensation for the property right taken.
Thank you. Thank you, Mr. Hillman. Mr. Gleiter? Or was it Mr. Glater?
Grater, Your Honor. Good morning, Madam
Good morning.
Chief Justice, and may it please the Court. Philip Grater for the property owner, William Devine as trustee, and with me is J. Owen Todd. Your Honors, the question was put very well to Mr. Hillman, which is, isn't notice required? This case is about notice because notice is the due process requirement for taking private property.
Your client didn't own the property at the time of the taking. Does he have standing to contest the taking?
Correct, Justice Cowan. My client did not own the property in 1968 or 1970, but he has been found to be a subsequent bona fide purchaser for value by the trial court, which meant that he took taking under a valid deed without notice of the purported clout on title, the town's claim.
And that gives him standing?
Well, under historical precedent, it would not give him standing to seek a damages award under Chapter 79, Section 6, because historically that right to a damages award is not a chosen interest, as the Court has said, that passes by deed. But should the Court find that a damage award is appropriate, that would rest with Karmer's estate, and as Mr. Hillman conceded, our client would have an equitable lien on that result.
I guess your basic position is this whole thing went off the rails when the town failed to do any reasonable investigation at all to find out who owned this property, and just simply recorded the order of taking, correct? And everything sort of flows from that.
Yes, Your Honor. Actually, our position is that the taking was void ab initio, and that the award of damages and the statutes of limitations as found by the trial judge.
But if he had had notice of the taking, how would he have contested it?
If he had notice?
If he had notice, how would he have contested it?
If Mr. Karmer had notice of the taking, either actual or constructive, which he had neither in this case, then it's our position certainly the statute of limitations would have run against him to challenge the taking in that time. He could have brought a civil action against the town.
What, in your view, constitutes reasonable inquiry as to the owner of the land?
Well, Madam Chief Justice, it's very clear in this case that what is not reasonable inquiry is no inquiry whatsoever.
No, I understand that, but we sometimes have to look at what the impact will be elsewhere.
Well, I think the
Where would they have had to have looked to identify who the owner in this case was?
The Registry of Deeds. And the trial judge expressly found that any prudent title examiner would have found that Karmer was the record title holder in 1968. There's an unbroken chain of title from Karmer back to the original subdivider.
I thought that there was a glitch between Loomis and Loomis's, the New Jersey Loomises.
The issue you're referring to, Justice Marshall, is that, yes, Loomis died and devised his property to his sisters, Caroline and Mary Loomis, who then deeded the property in 1923 to Karmer, and the deed on its face recites that they are the Devises and sisters of Mr. Loomis under a will in Somerset County, New Jersey.
So if I look at the Glantor Index, I can trace it back?
Yes, Your Honor. The trial judge found, because based on expert testimony put in, uncontested expert testimony, I would suggest, put in at trial, that any prudent title examiner would have found the 1923 deed precisely because The deed on its face recites that it concerns the locus. It recites the authority of the sisters. The trip to New Jersey that Mr. Hillman would think that have you believe that all towns and cities will now have to take is a bit of a red herring. Our title examiner confirmed the sisters' authority by obtaining a copy of George Lummis's will from a probate court in New Jersey. Nonetheless, the deed on its face recites the authority and would put anyone...
I suppose it's your position that had they given notice and for some reason the will had not been valid or it wasn't good title, you wouldn't be standing here. They would have made reasonable inquiry.
Well, precisely. If they had made a reasonable inquiry, found that the property was owned by Carmer, taken it as against Mr. Carmer, my client wouldn't have purchased it.
May I ask you this? As you know, there are two First Circuit opinions. It's federal law. It's not the same law, but it's due process is essentially what the issue is. Why would we not be inclined to go in that direction, which is to say, certainly there's no notice, but the impact of that is not to set aside the taking, but to provide damages?
Well, several reasons, Your Honor. First of all, it's hard-pressed to believe that the town's position is that its unconscionable conduct revealed in the Haddon case is something on which it would like to rely in this court. But nonetheless, you're correct that it is federal law, and the Haddon case expressly states that state recording statutes do not apply to federal condemnation proceedings under the Supremacy Clause. So all of the requirements of Chapter 79 would not apply to the federal government. Secondly, condemnation proceedings in that case.
But what's so different about Chapter 79? In other words, it doesn't apply in federal takings, but there's nothing substantively different.
Well, the fundamental difference here is that the owner was known. There's nothing in the record to suggest. I mean, Mr. Hillman suggested that the owners may have been spouses of town officials and there may have been some public knowledge, but it was a vastly larger parcel of property in the Haddon case, and there was no express finding, which there is in this case, that the owners were reasonably ascertainable by any diligent search.
Is there any explanation? And I mean, I've read the judge's findings, but why they looked at the tax rolls and not why they didn't do a grant or grantee search?
Well, actually, Your Honor, we don't know for certain that they did look at the tax rolls. The judge found that it was likely that they looked at the tax rolls based on the former town council's testimony that would have been ordinary to do. That would have been what was done. What's important, though, is the tax rolls themselves do reveal that Carmer was the record owner. He was assessed taxes from 1925 to 1929.
When's the taking?
The taking was 1968 and then two in 1970. And as of 1968, the current assessor's records, as our trial expert found, would have revealed owners unknown in the assessor's office. But he also found a reasonably prudent title examiner would have walked down the hall in Nantucket, to the Registry of Deeds and promptly found Carmer. But nonetheless, the assessor's records in their entirety do reveal assessment to Carmer between 1925 and 1929. That's an exhibit in the trial, and it's in the record in this case. So it's not the case that Carmer did something to stop paying taxes. There's no tax taking as against Carmer in this case. His name dropped off the tax rolls, and the town now asked this court to allow it to rely on its own previous, whether it's incompetence or whether it's simply its inability to fulfill its obligations, to now rest on that and say that looking at those admittedly faulty records was the sufficient inquiry.
Is there any case that says when you have this kind of problem, you set aside the taking as opposed to just awarding damages?
Yes, Your Honor, not in this precise. This is a case of first impression. There are no cases I was able to find in this Commonwealth that had this type of facts where the owner was knowable yet declared to be unknown without an investigation. But takings, this court has set aside takings in the past in both the Watertown v. Dana case and in the Radway v. Dennis case.
For what reason?
Those are failure to comply with the prerequisites of the recording element of Chapter 79. I mean, Chapter 79, Chapter 79 essentially embodies what due process requires, and it's a changing.
Sure. Mr. Glaber, did you try the case?
Yes,
okay.
Your Honor.
What did the town say was its reasonable investigation? I mean, who has the burden? I'm looking at the 79.7d requirement, the reasonable investigation.
Well, we've took the position at trial and take it again that as a subsequent bona fide purchaser, having established that, the burden would shift to the challenger of that status to assert that Mr. Devine was not the bona fide purchaser for value. In fact, the court expressly found, as a matter of fact, that Mr. Devine had no notice of this taking. So we met our burden, and the town did nothing to meet a burden to challenge that.
Did they put in any evidence of?
No, Your Honor. The evidence consisted solely of testimony by Foley Vaughn, who was the current airport commission chairman and former town council, who stated that the town, and I believe I'm quoting, paraphrasing, would have done what was necessary. But there was never any evidence put in on behalf of the town as to what was necessary. He testified repeatedly at trial, and it's in the transcript you have, that they would have done what was required, but he was unable to state what was required.
Would a prudent title examiner, besides examining the grantor-grantee index, just to be certain, go and look at town takings or notices that the town records?
Well, certainly, Nantucket's been a town for it's been a number of years, but it's not within the scope as our title examiner. Our title examiner went to exhaustive efforts to find these, and he himself testified in the trial court, adopted the fact that they were unfindable.
What was unfindable?
The orders of taking through the
Why were they
ordinary
unfindable? Your adversary said that they were recorded in the proper way in the registry.
They were filed in the registry, and they bear a book and page number, but they were, in the words of our expert, invisible.
They're not connected to any name that would be ascertainable, correct?
They're not connected to any name, and they're not indexed, and that, I would suggest, is evidence of a failure to meet the recording statute
They're not
requirements.
indexed by any plot or any manner of, I mean, if a title examiner goes and says, oh, I want to be sure nothing's happened to this land, hasn't been taken, can they go and find by a page and book number that plot and see if there's been any town action?
The trial judge found, adopting our expert's testimony, that one cannot find these orders of taking in the registry of deeds unless you know that they exist already and where they are located.
And that's a big point, isn't it? Because here the judge has heard this examiner, who's an expert witness, and accepted his testimony.
Yes, sir.
And we can't really dispute that in any way, shape, or form.
There's nothing to suggest
and
a
that
clear
takes
error.
you well down the road, doesn't it?
Well, it distinguishes this case from all of the precedent in this Commonwealth where applicants seeking to undo or overturn a historical taking have been unsuccessful.
Does it distinguish this case from the federal cases that were cited?
Well, the cases are distinguishable for reasons that I cited, but also it's not clear from in the Haddon case, and I'm not as familiar with the facts as I wish I were, but one of the elements that is not present here is inquiry notice. Oftentimes in public takings, the town proceeds, for instance, in the not in the Marymount case, in the White House v. Sherburne case, they proceed to build a municipal dump on the property, or they proceed to build a bridge on the property. And that places any prudent purchaser on inquiry notice that someone has a claim to your land. In this case, the town did nothing.
Well, as I understand it, it was your client's attempt to construct something that triggered
Yes,
somebody. Was there evidence? I'm looking at the judge's findings, and I don't quite know. Did somebody in the town remember that this was part of a taking some 30 years before?
It's not clear exactly what triggered the notice. It's clear that the owner's excavation of the property, he dug a well, putting batter boards down, and began the proceedings to dig a hole on the property to erect a house pursuant to a building permit the town gave him and a septic permit the town gave him. That somehow triggered somebody in the airport commission, it's not clear who from the record, that we may have a claim to this property. And then a letter proceeded actually from Mr. Hillman to another lawyer representing my client.
Mr. Glaber, this is beyond the scope of this case. Wherever the takings file was located, were there other takings at the same time?
It's not clear, Your Honor. In fact, that raises an interesting issue. The Airport Commission was able to produce records from 1967, 1969, but was not able to produce records from 1968 and 1970. There are no records in evidence in this case or below or in the record of what the town did, if anything, to find the owner of this. I'm not familiar with any other
How do we know that there was a taking in 1968?
Well, we have an order of taking, which is in the record, I believe it's Trial Exhibit 7, that recites that it is an order of taking adopted by the airport commissioners, and on its face, admittedly on its face, it appears to take for certain purposes certain property. What the crux of this case is that the order of taking recites that the owners were unknown, but the owners were readily ascertainable and, in fact, as Justice Cordy suggested, known. What is
Did your client challenge the existence of a taking? I know there's an order, but did your client challenge and to say, I don't have the board vote, I don't know whether there was a quorum, I don't know if it was published, I don't know anything?
Our challenge does not concern the public meeting at which the taking took place, because we have no evidence of what happened. It does not challenge the signatures on the order of taking. What it challenges is the town's fulfillment of the recording element of effectively adopting an order of taking. What this Court has historically said is failure to record, failure to do all that is necessary to record, whether it's late, whether it's failure to pay a recording fee. In those cases, this Court has said the taking was invalid from the beginning.
So you're not really challenging the due process lack of notice with respect to the taking itself?
Well, Your Honor, due process is inherent in everything to do with eminent domain proceedings and the eminent domain power. We did not at trial assert a separate constitutional cause of action, but certainly the failure to give any notice to my client's predecessor in title, whether actual or constructive, was a due process violation. And it happens to be a violation of the statute. The trial court did not find need to resort to constitutional principles to decide this case, but constitutional principles certainly underlie it. What's important to notice, you mentioned notice, actual notice, as Mr. Hillman should say every time he made the word notice, actual pre-taking notice has not been required historically by this Court. Due process, and this Court suggested it in its opinion in 1974 to the House of Representatives, suggested that pre-taking notice may be required by modern due process statutes, and the New England Legal Foundation had certainly adopted that position, and it's consistent with ours. Actual notice is not, but that's only because constructive notice is its legal substitute. Where you have neither actual nor constructive notice, you have no notice, no due process, and no taking.
Mr. Glade, if I could just go back, I haven't looked at the record, so I haven't looked at Exhibit 7. If I look at Exhibit 7, is it limited to the parcel of land that your client acquired, or is it a larger parcel of land?
There are three orders of taking, Exhibits 7 through 9 in the appendix of exhibits, Your Honor. The 1968 taking has four parcels, two of which are abrogation easements are taken. We are parcel 3, and what was taken was Block 285. My client's property is the lower third. It's lots 17 through 26 of Block 285. But they took the entire block, assessed it against, and named it as owners unknown. It's really 3 individual parcels. What it's telling, though, is the order of taking recites Block 285 as shown on a recorded plan in the Nantucket Registry of Deeds. So the Airport Commission had the plan. It's Trial Exhibit 21 in your book. Had the 1890 plan. It was obvious it was a subdivision. And as the trial judge correctly found, they did nothing to follow the chain of title to find out who owned that property.
Thank you, Mr. Glade.
Thank you, Your Honor.
Good morning, Mr. Talcott.